Hello, good evening, class, and welcome to the last part of the coverage for our midterm, chapter 4 on limited partnership. Now, limited partnership is quite a short chapter. Um, it covers Article 100, no, it covers Article 1843 until 1867. Now, what is limited partnership? So, under Article 1843, it defines what is limited partnership. Limited partnership is one formed by two or more persons under the provisions of the following article, having as members one or more general partners and one or more limited partners. The limited partner, as such, shall not be bound with the obligations of the partnership. So basically, limited partnership talks about having a general partner and having a limited partner under the partnership. When you say limited partner, the limited partner is only bound up to his shares or up to his capital, and the limited partner is not bound by the obligations of the partnership. So, how is a limited partner created? Basically, it is created by the parties after compliance of the requirements of law. So, we have what are the requirements under the law? You can read it under Article 1844. So, if you have a certificate, no, it states there, no, you can just read it in 1844. Those are the requirements of the law in order to create a limited partnership. So, what makes a limited partnership different from all other partnership? In the name of the partnership, there must be the word limited. No, ABCD Partnership Limited or LTD. Why is that so? That is in order for the partnership to inform the public that there is a limited partner. Because again, the limited partner is not bound with the obligations of the partnership. So those are just one of the requirements, no, that shall be stated in the certificate. And then um the rights of the limited partner shall be given there. The rights of additional limited, basically you lay down the rights of the limited partner, the additional limited partner, the substituted limited partner, and the remaining general partners. Because again, the limited partner and the general partner have different obligations. Okay, and then file for the record the certificate in the office of the Securities and Exchange Commission. A limited partnership is formed if there has been substantial compliance in good faith with the foregoing requirements. So, again, what are the requirements? Certificate of limited partnership, and the certificate must be filed in the office of the Securities and Exchange Commission. Not like the other kinds of partnership wherein you can just constitute the partnership even without registering it with the Securities and Exchange Commission. But that is different for the case of limited partnership because it is clearly stated under the law that for the limited partnership to exist, the certificate of limited partnership must be registered with the Securities and Exchange Commission. Okay. And then 1845, the contributions of the limited partner may be in cash or property but not in services. What does it mean? A limited partner can only be a capitalist partner, but he cannot be considered an industrial partner. Again, when we say industrial partner, these are the partners who give their expertise, their services. So if you want to be a limited partner, you can only be a capitalist partner. 1846, the surname of the limited partner shall not appear. No, shall not appear in the name of the partnership. So if si partner E ang limited partner, it should be ABCD Partnership Limited. However, the name of the limited partner uh, may appear in the partnership name if it is also the surname of the general partner. What if pareha og apelido si Mr. E ug si Mr. A? Then both their surnames will appear in the name. Or prior to the time when the limited partner became such, the business has been carried on under a name in which his surname appeared. So, what if sa una, general partner si Zad, then he became a limited partner? So, if it has been used for a long time before he became a limited partner, then they can continue the usage of the name. A limited partner whose surname appears in a partnership name contrary to the provisions of the first paragraph is liable as a general partner to the partnership creditors who extend credit to the partnership without actual knowledge that he is not a general partner. Okay, so uh, why is this so? Because again, the limited partner is not bound by the obligations of the partnership. Ang isang obligation na is loss according to his capital. So if you put the name of the limited partner, it is presumed that he is a general partner and he is bound against the partnership creditors. So that's why you do not put the name of the limited partner. Okay. So, okay, we already discussed the contribution. And then membership, it must have at least one general partner and at least one limited partner. So, dili pod pwede nga puro ra limited partners. Kinahanglan jud na at least usa ka general and then mga limited. Or the other way around. Basta kinahanglan na ay general na apoy limited. And then the extent of liability, limited partners are liable only to the extent of their capital contribution. So we already said that, no? That is why naatang mga rules nga dili pwede nga ang limited partner mo appear ang isangan sa partnership name because he is only liable to the extent of his capital. Okay. Basically because his liability is limited, the limited partner cannot participate in the management. No, he cannot manage the business of the partnership. Only a general partner has the power to manage the business of the partnership. So, ang si limited partner, igo na ni sila mo dawat sa profit or sa losses. And then the limited partner has no prohibition to engage in a business similar with a partnership. Now, if you remember, there was a prohibition in partnership wherein a capitalist partner cannot engage with a business that is similar with a partnership business. However, because the limited partner is not mentioned in the name and he is not he is not bound by the obligations of the partnership, he can also engage in the same partnership business. So, kung ang ABC Partnership Limited, wherein Mr. E is a limited partner, is engaged in selling computers, and XYZ Partnership Limited, wherein Mr. E is also a limited partner, it is allowed because there is no such prohibition in limited partnership. And then assignment of interest, no? In Article 1859, it states there that a limited partner's interest is assignable. Pwede ma-assign ang iyang interest to the partnership. Now, if it is assigned, there is what we call a substituted limited partner. That is why in the certificate of limited partnership, you state there, the partner should state there what are the rights of a substituted limited partnership, because it is allowed under the law. Now, what again is a substituted limited partner? It is a person admitted to all the rights of a limited partner who has died or has assigned his interest in the partnership. So, there can be a substituted limited partner upon the death of the limited partner, or he has voluntarily assigned his interest in the partnership. If you remember, if you are a general partner, if you assign your interest, the assignee does not become a partner. But in limited partnership, the assignee becomes a substituted limited partner. So, mo po na yung difference. Kaya again, sa limited partner, the extent is only upon the capital of the partner and not necessarily the obligations of the partnership. So, before an assignee becomes a substituted limited partner, there are essential requisites. However, first, all the partners must consent, or if the limited partner assignor has a being powered in the certificate of limited partnership gives the assignee the right. Or if it is not stated sa certificate of limited partnership, it must be amended para mahimo ng substituted limited partner. And the certificate of partnership must be registered in the Securities and Exchange Commission. So again, for example, namatay si limited partner E, so you assign. No, ma-assign na ang rights ng limited partner. If it is written na in the certificate of limited partnership, then we have no problem. However, if it is not written in the certificate of limited partnership, then all partners must consent. And then you amend the certificate of limited partnership, and then you register it again with the Securities and Exchange Commission. Okay. So the substituted limited partner has all the rights and powers and subject to all the restrictions and liabilities of his assignor. So if the assignee is a substituted limited partner, basically he is only liable to the extent of his capital, and he cannot manage the business of the partnership. Okay, retirement, death, insolvency, insanity, or civil interdiction of a limited partner does not dissolve the partnership. Why? Because again, the interest of the limited partner can be assigned. So it does not dissolve the partnership. Unlike sa general partner, the effect of death, insolvency, retirement, and insanity of a partner dissolves the partnership. Okay. And then you can just read Article 1863. This is the dissolution. Okay, 1863 is the order of payment if there is dissolution. Kinsa may una bayaran in a limited partnership. So first is the creditors. No, creditors except sa creditors of the limited partners. And then next is the limited partner na dajon. So creditor, and then limited partner in respect to their share of the profits. And then third, limited partner in respect to the capital. So lahi siya sa katong usa nga dissolution. Diba kay sa katong usa ka dissolution sa normal ra nga partnership, creditors, and then creditors who are partners, and then partners capital, and then if napay surplus, partners profit. But here you pay the creditor, and then you pay the limited partners profit, and then you pay the limited partners capital, And then general partners, other than for capital and profit, general partners in respect to profits, and general partners in respect to capital. So, medyo different ang way sa pagsettle sa accounts in case of dissolution if limited partnership or you have the generic nga partnership. Okay. And then, when can you cancel the certificate of partnership or when can it be dissolved? Um, it can be canceled when when all the limited partners cease to be such. So, for example, mo hawa na ta ng limited partners because they want to be general partners na. So, the certificate of limited partnership will now be canceled. But it can also be amended. So, we have here in 1864, 1 to 10, these are the instances where you can amend the certificate of limited partnership. So if there is a change of name, there is a substitution, there a person is substituted as a limited partner, additional limited partner is admitted, a person is admitted as a general partner. So you have there 1 to 10. So there are only two ways wherein the certificate of limited partnership can be canceled. First, when the partnership is dissolved, and second, when all limited partners cease to be limited partners. In all other cases, it is only amendment of certificate of limited partnership is required. So, exception to the rule ang paragraph 1 to 10 sa Article 1864. Okay. So basically, that is limited partnership. And you can go to page 171 if we are using the same book. There is a table which basically um, differentiates. No, it differentiates general partnership from limited partnership. So that ends our coverage for for the midterm. Again, we will cover chapter 3, dissolution and winding up, and chapter 4, limited partnership. So if you have questions, you can ask me in our group chat. Thank you and good evening.